So welcome class. We are going to discuss the ATD level 1 paper, and this is a paper that was done on 1st of August 2022. So let's go straight to the questions, and this is question 1 of that paper. Explain the four different forms which an arbitration agreement might take. Explain the four different forms in which an arbitration agreement might take. Okay, so let's create some space to be able to answer that question. Explain four different forms which an arbitration agreement might take place. Now, there's normally arbitration is, and in most cases, students confuse between these terms. We have negotiation, then we have arbitration, and we have the mediation. All of them are dispute resolution ways. Dispute resolution ways. But there's a slight difference. For negotiation, we only have the two parties who are in conflict, or the parties in conflict. In most cases, we talk of two. But generally, we are talking about the parties in conflict only. So we don't have a third party coming in when we talk about negotiation. They are the ones who will disagree to agree. And then for arbitration, we have a third party whom they are going to, the parties in conflict, that is, they are going to agree on this third party, and the third party will make a decision on their conflict. And that decision made by the third party will be binding on these conflicting parties. So the conflicting parties agree to involve a third party who will hear both sides and make a decision which will be binding on the two parties. That is arbitration. Then for mediation, yes, mediation will still have a third party, but the third party will not make a decision on behalf of the conflicting parties. The third party will only help them to reach an amicable solution, or that position that is favorable to both of them. So it will only help them, will provide a platform for them to arrive at a decision that will be binding upon themselves. So it's not the third party that comes up with the decision. That is called mediation. I hope it's very clear. For mediation, the third party doesn't make the decision that will be binding on the two parties. He only leads them to a decision which will be made by themselves. Then for arbitration, the third party will make a decision on their behalf which will be binding on them, those two parties who are in conflict. Then for negotiation, we even don't have the third party in the first place. So the question here is, explain four different forms which an arbitration agreement might take. Now somebody might wonder, are we talking about forms as in forms papers, or forms the different ways? But I think the best way to answer this is to go to the act itself, because we have an arbitration act. We have an act called Arbitration Act, and I've just opened it here. This is the Arbitration Act in the laws of Kenya, and we have a specific area here where they are talking about the forms of arbitration. You can just check forms of in fact, it's here, general provision. You can see this is forms of form of arbitration agreement. And I think this is very much in line with the question that is before us. The question is, explain four different forms which an arbitration agreement might take. We are talking about forms of an arbitration agreement in the other side. So we'll simply go back there and see if we can raise the 4 points that are expected by the examiner. So forms of an arbitration agreement, the first thing under general provision. So there we go. We have it there, the form of arbitration agreement. So that is a question that we've been asked, the four forms of that an arbitration agreement may take. Number one, that an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Now, before we can go the arbitration way, there must be something that permits us to go the arbitration way. And in most cases, when you are entering into a contract, there's always a clause that is supposed to be included on how you plan to resolve conflicts should they arise. So when you're talking about arbitration, then there should be this clause in that contract that says that should there be a conflict, then we plan to go the arbitration way. That clause is very important before you can settle for an arbitration agreement. And that is what we are talking about here, that an arbitration agreement may be in the form of arbitration clause in a contract or in the form of a separate agreement. We can come up with the separate agreement that should we have a conflict, then we'll go the arbitration way, or we can have the arbitration clause. Clause is just like a paragraph in the main contract that shows how you will go about resolving conflicts should they arise. And then the other form of arbitration agreement is that an arbitration agreement shall be in writing. It must be in writing. Any agreement that is going to take place must be in writing, of course, by the parties involved. And these parties involved must sign. You can see it must be signed by both parties. There must be a date to that particular write-up. Must be there. Then, of course, we have a lot of stuff like, this is email, other means of communication which will provide record of the agreement. All those other stuff that will make the contract valid, they must be there. Actually, they are quite a number. I don't know if I'll have them here. Yeah, but they're quite a number. Then what we can just say is that the arbitration agreement must be in writing. It must have been signed. It must have a date. And then the clause itself, the arbitration clause, must be included in the original contract or a separate agreement at that before it can be performed. And then, of course, we also have this on an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other party. Yeah. For an arbitration to take place, of course, we should be talking about something that we agree on. Both parties in a conflict agree on something, but there is just some minor differences. And you can see it's even here that it should be in the form of, I think the best part for us to capture is here, is alleged by one party and not denied by the other party. See, it's alleged by one party and not denied by the other party. So it means that they are in agreement to some greater extent. It's only that there is a conflict that exists, maybe some small percentage, which they want to iron out. So that should also is very important when we talk about arbitration agreement. And then the reference to the contract. Of course, we said that the arbitration clause must be in the contract, so there must be a reference to that contract that shows it is the contract that will be the guiding book towards reaching a resolution. There must be some guidance where they are going to draw the conclusion from. So the reference should be made to the contract that they made initially. So that's what number 4 is saying, that the reference in a contract to a document containing an arbitration clause shall constitute an arbitration agreement if the contract is in writing and in reference to such, and the reference is such as to make that arbitration clause part of the contract. It is the contract that will guide the whole of this arbitration process, but there must be a clause in that contract. So reference, very important. It must be written, very important. There must be a clause in the original contract, very important. Must be signed. There must be details of the parties. And then what we are saying is that the parties must also be in agreement to a greater extent, especially on the basics of the contract, so that what we are just talking about here are just nitty-gritties, the source of the conflict. So this will help us answer that question, and you can see there are 4 points. This is what the examiner required when he asked the various forms that an arbitration agreement might take. These are the answers: 1, 2, 3, and 4. So then we move to part B of that question. Part B of the question. So we've said there must be an arbitration clause. Arbitration clause must be written. Then number C, we said that it must be signed and must have a date signed by both parties and have the date plus and other particulars. And then number 4, we said that there must be reference to the contract. Reference to the contract. So those are the 4 major forms, the 4 different forms which an arbitration agreement might take. Okay, let's look at item B. Explain the legal liability of the following: unincorporated association and artificial persons. Now, the legal liability of unincorporated associations. Unincorporated associations are actually the opposite of this is simply will be the incorporated association, incorporated companies. Let's just talk about companies, because companies are incorporated. So the opposite of this will be the companies. Unincorporated associations, we talk about things like trade unions, yeah. And normally what happens is that these are associations of people. People have come together and of course to do something, to pursue some interest, but they have not been incorporated. So it is not recognized in law as one body that can enter into contract in its own name. It is not incorporated. When it's incorporated, it means that it is recognized as an artificial person and it can enter into contracts in its own name. And when it enters into contracts in its own name, it means that it is liable in its own name. It can take the responsibility. Now, this one is an incorporated association. So what simply this means is that, yes, people have come together to pursue some interest, but the decisions that are reached by whoever it is that makes the decision will not be binding to the to the company as a whole. But each of these individuals involved in the decision-making process will have to carry the burden by themselves. Just like in partnership. In partnership, the partners are responsible for the liabilities of the partnership business. So for unincorporated associations, in case something befalls the organization, the people who are behind that organization will have to carry the liability by themselves and not the organization as a unit. That is what we mean by these unincorporated associations, especially when we talk about the legal liability status. So that is the position that the individuals involved in making decisions for unincorporated associations will have to be responsible for all their decisions at a personal or individual level and not at a company level. Then for artificial persons, a very good example is a company now, an incorporated company, incorporated. And we will normally talk of, before we can have a company, there's a certificate that is issued, which is called Certificate of Incorporation. And it is this certificate of incorporation that makes it an artificial person. So once it becomes an artificial person, it means that it can enter into contracts in its own name. It can sue and be sued. It can own property. it has limited liability, and this limited liability is our area of interest, to which now answers this question. Legal liability. Limited liability simply means that the owners of or rather the shareholders or the owners of the company really don't carry the burden of the company unless otherwise. We talk of the otherwise could be in the cases of lifting the corporate veil, but otherwise the company carries its burden with itself. Should the company maybe not be in a position to pay its debts, it is the company's assets that will be interfered with. If the company makes a certain decision, it is assumed that it is the company and not the people behind the company, unless you have exceptional cases where the court might want to lift the company veil and see the people who are behind a certain decisions. But those are exceptional cases. Otherwise, for artificial persons, a very good example is a company, their liability is limited to the institution that we are talking about. And in this case, good example is a company. So what have we concluded? That here we don't have no limited liability. Limited liability. Liability extends to the parties who make the decision on its behalf. And then for artificial persons, we have limited liability. It's limited to the company and not the people who are behind the company. Okay, let's go to item number C. Item number C. And this C is asking on describe 4 acts that might constitute a detinue. Describe 4 acts that might constitute a detinue. Now, a detinue, this is one of the items found in the law of torts. It's actually in the law of torts, and the law of torts alongside defamation is this one, defamation. Then we have what is the name? Trespass. Yeah, alongside those other torts, detinue is also one of them. And there are 4 elements required to establish the detinue. The question here that we have before us is describe 4 acts that might constitute a detinue. So these basically goes hand in hand with the elements that will constitute a detinue. Those are the acts that the question is asking for. And number 1 point here to note is that, maybe before we go to the point, what is a detinue? A detinue is basically wrongful detention of somebody's property. Wrongful detention of somebody's property, especially after he has already demanded for that property and the other party just either stubbornly refuses to release the property to him or something like that. But it is, in a nutshell, you can just say that it is when a person wrongfully detains another person's property, and I might say unreasonably or for no good reason. You don't return or release the property to the rightful owner of the property for one reason or the other. That is what we mean by detinue. So, 4 acts that might constitute detinue. Number 1 is that there must have been a demand. There must have been a demand. And of course, demand comes from the rightful owner. Rightful owner. So the rightful owner demands for his or her goods or property in the goods. And So he demands for the property in the goods, and then, of course, the second act is that the demand is refused. The demand is refused, of course, by the person in possession of the goods. Possession means that you have the goods at your custody, but they don't belong to you. You don't have the right to the title. So in this case, the person who is demanding the goods is the one who has the right to the title. So he's demanding for the goods, and then you who is holding the goods, which are not yours, you refuse to give in to the demand. So that is the second act that might constitute a debt. Number one, there was a demand from the rightful owner. Number two, the demand is refused. Number three, the refusal is unreasonable. If it's reasonable, you have grounds against which you are refusing, then it may not constitute a debt. But if the refusal is stubborn, is unreasonable, there is no reason why you should refuse because the property doesn't belong to you, but you go ahead and stubbornly or unreasonably refuse to release the goods, then that might constitute a debt new. So the refusal is unreasonable. And number four, as a result of this refusal, of course, there is damage, and presumably the damage now will be suffered by the rightful owner. He has asked for the goods. You've refused to give in to the demand, and the reason for that somehow is unreasonable or stubborn, and as a result of the refusal, unreasonable refusal, whoever was demanding the goods, who most likely is the owner, suffers losses or damages as a consequence. If that is the case, then that will constitute to debt union. So these are the four acts that might constitute to debt union, and they should be present for somebody to run to the court, of course, to claim this. We have, of course, remedies. The court might order the delivery of goods. It might also instruct damages, compensation, restitution. All those are some of the things that the court might decide. Otherwise, these are the answers to that to this question. And let's go to part D of the question. Differentiate between ownership and possession. I think I've already talked about this. Ownership is right to property. Right to property. And in most cases, we talk about title or entitlement to the property. To become the rightful owner of the property, or you are the rightful owner of the property when we talk about ownership. The other side, we have possession. Possession, you don't have the right to the property. Possession, you only have what? The custody to the property. Custody to the property. You have custody to the property. Possession means that you have it now, but you could be having it, but it doesn't belong to you. It belongs to somebody else. So it can belong to party X, but you have it. You are using it, but it belongs, the real title belongs to party X. So in such like a case, the owner will be X and you will be the possessor. The other difference possibly that might exist in these two terms is that the owner can also be the possessor, but the possessor, how do we put it? You can have the right, you can be the owner and you also possess. I think let's not go there, but let's just stop here. That ownership is the right to property, you have the legal right to the property, and then possession, you have the custody. So you have the possessory rights only. You just have the custody to the property. And of course, if you have the custody to the property only, it means you cannot transfer a good title to the property. But of course, the owner, whoever has the ownership, can transfer, can pass a good title to anybody else. Whoever is in possession may not transfer the title to anybody else because he doesn't have the entitlement of the property. So I think that should come out clearly. And because it's 4 marks, I've already given you the two major differences between these terms, and I think we can work with that. Right to property, and because of the right to property, he can pass a good title, he can transfer the title to another third party. This one only has the custody to the property, and because he doesn't have the title, he may not be in a position to transfer the title or pass title to another party. Okay, that is question 1. Thank you. Let's meet in the next question to discuss part 2 of this paper. Thank you.